Welcome, everyone, to Banking and Consumer Affairs, where Floyd the Barber's favorite president, Calvin Coolidge, once said, "It's better to kill a bad bill than to pass a good one." So that's kind of our motto in here. But we're glad to have everybody today, so thank you all for coming out. I want to recognize, too, that we have a group here from the Tennessee Mortgage Bankers Association. Would you all care to stand or raise your hand? We just want to recognize you and thank you all for coming out. So if you need a low-interest loan before you leave here today, please check with one of them, and they'll be glad to do that. Thank you all for coming, though. We really appreciate it. Okay, and Madam Clerk, would you please call the roll?
Representatives Boyd, Bricken, Camper, Faison, Haston, Lynn, Powell, Vaughn, Chairman Powers. Chairman, you have a quorum.
All right, thank you. Do we have any members that have any kind of personal orders or announcements today? Any at all? Okay, let's kick it off. We got a little housekeeping to do. Item number 4, House Bill 1856 will be placed on our final calendar. Got to hit the gavel. Thank you. Item number 6, House Bill 1835 has been taken off notice. Item number 8, House Bill 2398 has been rolled 1 week. Item number 9, House Bill 2396 has been rolled 1 week. And like to all remind you all, if you all do have a social media related bill that'll be assigned to this committee, the last day to put that on notice is today at 3 o'clock. We're going to have a social media calendar next week. So 3 o'clock today is the deadline. And that leaves us with 5 bills on the calendar. We'll start off with item number 1, House Bill 2187 by Chairman Boyd. Chairman, you are recognized. And we have a motion and a second. Chairman Boyd.
Thank you, Mr. Chairman. This piece of legislation deals with workers' compensation law, and this makes some very minor changes. The 2013 reforms created the workers' comp court system where there are 12 trial judges with 1 chief judge and 3 appeals board judges. The trial judges currently are eligible for up to 3 6-year terms. The chief judge and the appeals board judges are only eligible for 2 6-year terms, and this simply changes that to allow for 3 6-year terms for everyone, which creates some uniformity. I'll take any questions, Mr. Chairman.
Okay, are there any questions on the bill? Do we have a question on the bill?
Call the question.
Question on the bill. All in favor say aye.
Aye.
All opposed? No. The ayes have it. And House Bill number 2187 moves on to full commerce. Thank you, Chairman Boyd. Okay, number 2, House Bill 1636 by Representative Griffey. Representative, you are recognized. We have a motion and a second. Representative Griffey.
Thank you, Mr. Chairman. Thank you, members of the committee. House Bill 1636 is the E-Verify bill. We currently have E-Verify in Tennessee, but it's limited to employers with 50 or more. Just briefly, Tennessee...
Pardon me. Is there an amendment on the bill? Do you want to go ahead and put it on first?
I'm not sure that I have an amendment. I don't.
I have one that has drafting code 013961.
That sounds right, Mr. Chairman. I don't have that amendment on me.
Okay. Do you still want to put it on?
Yes, could we please?
Do we have a motion on the amendment? And a second. Okay, all in favor say aye. All opposed, no. We're putting the amendment on the bill.
And I think that changes the effective date of the bill, if I recall correctly.
Okay. Let me
briefly.
Let me just take a brief moment and get that amendment, okay? So we can.
Yes, Mr. Chairman.
Okay, do you have a copy of the
Yes,
amendment?
I
Do you want
do.
to explain the amendment then, please?
This amendment was drafted to address some of the concerns that I believe General Services had concerning the bill. And what it would do, it changes the definition of essential procurement officer, the chief procurement officer, and allows, if there's a dispute concerning E-Verify regarding state contracting or whatever, the General Services already has an in-house appeal procedure that they use. And what this would do, if enacted, if House Bill 1636 were enacted, this would allow any E-Verify issues that the state of Tennessee has to use the current procedure that's in place.
So it doesn't really change any kind of an effective date or anything like that?
No.
Okay.
No,
okay.
Mr. Chairman. My
Okay.
apologies on that.
That's okay. Okay, go ahead and want to explain the bill. We've already added the amendment, so just to explain the bill as amended, please.
Thank you, Mr. Chairman. Members, E-Verify is a voluntary, free online workforce verification system. It acts as a virtual wall that allows employers to compare information on employees' I-9 records at the Department of Homeland Security and Social Security Administration. It is in partial use in 22 states, but mandatory in Alabama, Arizona, Mississippi, and Tennessee. It's one of the highest rated government programs in terms of user satisfaction. E-Verify is a highly effective way to combat illegal immigration because it works to eliminate the illegal jobs magnets. Several studies have shown that the number of recent immigrants fell by almost 40% when a state had universal E-Verify law in effect. Illegal immigration fell as much as 50% in a single year in states with mandatory E-Verify laws. Mandatory E-Verify not only reduces illegal immigration, but also encourages illegal workers to return home. E-Verify protects American workers by ensuring employers only hire individuals authorized to work in the United States. And as in 2006, the NFIB in March and December conducted an in-depth poll regarding its members, and more than 90% of the NFIB members believe that illegal immigration is a serious problem. 86% said that finding a solution should be very high or high on the priority for Congress administration. 83% of their members agreed that employers who knowingly hire undocumented workers should be subject to fines and or other penalties. And 74% of NFIB members agreed that comprehensive immigration reform should increase Border Patrol and improve technology on the border. And 73% of the members agreed that employers should be required to use a government-run, not employer-run, verification system. And with that, I move for passage and hope I can answer any questions of any committee members.
Okay, and thank you, and thank you for the bill. You know that I agree with so many of the things that you talk about. We always have a little bit of a complication, but you made a great point there. And first up on the bill is Chairman Boyd.
Thank you, Mr. Chairman and sponsor. Appreciate your enthusiasm for this. You and I have been working on this since 2019 when you ran your first bill and we amended it and were able to get it, I think, to the floor. And we've been working on this, and you brought some awareness to it and probably breathed some new life into it. I know it had been a while since the legislature had addressed the E-Verify threshold. And as you know, I've put together a bill that I've been working on for a couple of years that expands the use of E-Verify in the state, but it's almost an omnibus bill in the sense that it does so many other things that needed to be done. It tied up some loose ends in the business community, and we were able to get that passed out of the subcommittee. And it passed yesterday out of full committee, and I think it's got some legs and it's well on its way to become a law. And I appreciate you co-sponsoring it with me as well, and your support on that bill. And so I think that one's going to get us where we need to go. And like I said, I want to thank you for your support of it. But I think we probably don't need to pass anything that undoes what you and I are working on that other piece of legislation. So I think we need to give it some space and see where it goes. So, Mr. Chairman, I would make a motion that we send this one to summer study.
We have a motion and a second. Any objection? Without objection, let's go to summer study.
Thank you, Mr.
Thank you,
Chairman.
Representative
Thank you,
Griffin.
members.
Okay. And the next bill, also by Representative Griffey, House Bill 2313. And Representative Griffey, you're recognized again. Oh, yeah, we have an amendment on this to have a motion and a second, and there's also an amendment.
Yes, I do
You have the
have that
drafting code on it?
013959.
Okay, that's what I have. To have a motion on the amendment. And a second? Got a motion and a second on the amendment. Representative Griffey, you're recognized. Please explain the amendment.
Thank you very much, Mr. Chairman. The amendment was, again, worked out with the administration and I believe the Department of Human Resources that if this bill were to pass, it would not prevent a person or an employer or employee to participate in mandatory compliance with federal civil rights law. It would not prohibit a person from reviewing, obtaining, or utilizing demographic data, and is not applicable if it would result in the person losing federal funding.
Okay, we're voting on the amendment. All in favor say aye. All opposed? The ayes have it. Okay, we're back on the bill as amended, and I think you have someone here that that wants to talk on the bill, and we'll be glad to, if you want to introduce her, we'll be glad to entertain her now, and we'll go out of session and hear her.
Thank you very much, Mr. Chairman, members of the committee. I have Dr. Carol Swain, a noted scholar, legal scholar, educator, and true patriot, and it's my distinct privilege to introduce her now and have her testify on the importance of CRT and her book, CRT, A Black Eye for America. Dr. Swain.
Okay, all right. Thank you, Dr. Swain, for coming. It's an honor to have you here today, and you are recognized.
Well, thank you so much for having me here. And I do have a book that addresses critical race theory. But as far as my support of this House bill, my support is based on our civil rights laws that are on the books, as well as the Constitution's Equal Protection Clause. And I think that there is a problem with compelling individuals to engage in mandatory sensitivity or diversity training where the goal of the training is not consistent with the law, and it can result in intimidation of certain people because of their race or their sex, as well as their if they're heterosexual versus homosexual. There are all sorts of issues that are coming from diversity training, the kinds of training that runs counter to our Constitution and civil rights laws. And so I think that that is the strongest case against CRT and the way DEI training has morphed. And when you look at diversity, equity, inclusion training, it's been around since the 1970s and 1980s. And up until recently, it was consistent with affirmative action. And we know that affirmative action is the law of the land. Affirmative action is still very much alive on the books. There are laws prohibiting sexual harassment, discrimination against racial and ethnic minorities, discrimination against the handicapped. That's the law of the land. And we get in trouble when we're trying to engage in social engineering and indoctrination that goes beyond the law. So that's my little preface. As far as my book, I have a book that was published last August called Black Eye for America, How Critical Race Theory is Burning Down the House. I wrote the book because there were so many people trying to figure out, mostly parents, what was taking place in our public schools with regard to CRT. And so the book explains what it is, where it came from, how it manifests itself in our society, why it is, and as I argue in the book, which is co-authored, it runs counter to Christian principles, it runs counter to our civil rights laws and our Constitution, and just who we are as American people, because it involves often shaming and bullying people because of the color of their skin or because of other factors about them, and it's just not who we are as American people. And so that's what I discuss in my book, Black Eye for America. And when it comes to where did CRT come from, critical race theory is a theory. And it's been on university campuses since the 1970s, and it has morphed down to K through 12 education. And the indoctrination that's taken place within our schools, it is easily documented, but it's also creating in our workplaces hostile work environments, because if you don't participate with certain types of programs or activities, then you kind of out yourself. You don't have your ability based on your conscience, based on what you believe, to opt out. And so there may be penalties that are paid. So that's why I think this legislation is very important.
Okay, well, thank you very much. We're going to have some questions for you. I think everybody's kind of interested. If you don't care, I'm going to ask one real quick, and then if anybody else wants to get on the list. But when you talk about, and I know we've kind of worked on this through K through 12, you know, we have that purview to look to do those, but when it gets into, you know, higher ed or the workplace, you know, that kind of, then we get into some problems because we don't want to tell, you know, higher ed or the workplace what to do or what they can't do. So we always try to have that freedom. But just talk a little bit about I know the diversity and equity and inclusion, even in the college campuses and a lot of other places like that. Is that part of aren't they working CRT kind of into that? Isn't that part of it? I mean, when they have,
Yes, it is.
because sometimes they have a whole department like that.
Yeah, I mean, think about it. Every business and government, we still have affirmative action. We have affirmative
Right.
action officers. Well, what has happened with diversity, equity, inclusion is there's a whole new layer, and it's informed by critical race theory. And so they use those tactics. It wasn't always that way. At one time, with diversity, equity, and inclusion, it was about going to maybe historically black or Hispanic or Native American colleges and universities, trying to recruit job applicants, trying to recruit students. So it was really about bringing more people into the system.
Right.
The meaning of equal opportunity, that's pretty much been rejected. Colorblindness has been rejected. Equity has been embraced, and equity is about equal outcomes, not equal opportunity. And so they've totally discarded equal opportunity. The people that are proponents say that racism is permanent, that only white people can be racist, and so white people have to engage in the permanent work of being anti-racist. And I think most of us would recognize that any group can be racist.
Yeah.
It's not confined to one group. We all have work to be anti-racist. And so that's very problematic. And when it comes to how it's being used in K through 12, we find that minority students, you know, they are told that they're victims, and standards are being lowered. Standards are being lowered. We're told that math now is racist, and that depending on your racial or ethnic group, you might not get the same answer to a math equation. And it's creating an environment where it's going to be very difficult for young people to succeed if they come from disadvantaged backgrounds. And for people who may or may not know my background, I came from poverty, high school dropout, married at 16. I got a high school equivalency, went to a community college, and earned the first of 5 college and university degrees. I was successful, I believe, because there was no one telling me that I couldn't do.
Right.
I believe that if I worked hard, you know, I could change the circumstances of my birth. I was able to do that. I had plenty of helping hands along the way. That was equal opportunity. But we're told now that, you know, standards have to be lowered. We see segregation. I grew up during the era where we fought for integration, and we see our society being resegregated. And in the workplace, they have these affinity groups now where they're encouraging people, you know, to break off in their little affinity group to feel safe.
Right.
And that's not conducive to keeping organizations on their mission, whether it's a private or public organization. It doesn't bring people together. It doesn't promote racial reconciliation and healing. It's very divisive. And critical race theory and DEI is very much rooted in cultural Marxism. And cultural Marxism grew out of economic Marxism. And it's based on conflict theory. You cannot bring harmony using conflict theory. And the research for some time now has shown that often when you bring in diversity, equity, and inclusion trainers, it leaves the workplace worse off Because if there wasn't conflict, if everyone were getting along before the training, afterwards, the whites are ashamed, bullied, or offended, and a lot of the minorities are angry. And I don't know what the goal is, because the goal doesn't seem to be to bring people together, to bring about harmony. I think that we'd be better off in this nation if we went back to the original desire of affirmative action to create opportunities, equal opportunities, to extend helping hands, to help people of all races and ethnicities overcome disadvantages and have equal opportunity. We have forgotten that. And I'm very concerned about the direction of our nation. And it started in the university campuses, but it's everywhere now. And I think it's very wrong. I think it's very dangerous. And that's why I'm here today.
Yeah, and I agree with you. And you made a great point too about equity and equality. I mean, equity is, I think, from Karl Marx. I mean, equal outcomes or equality. That's what we want for everybody. We want equality, equal opportunities. Actually, what we're wanting for everybody, not equity, not equal outcomes. So I think that word gets thrown around a lot, and everybody just kind of passes it off. But real big difference between equal opportunity and equity.
And social justice, I mean, that is a concept that we hear a lot about, but social justice is very much rooted in Marxism. It's, it's prevalent in our churches, and it too doesn't mean justice, because when you actually talk with the people that are pushing for social justice, they believe that they reject it.
Right.
The equality and non-discrimination, they very openly talk about they want discrimination for the disadvantaged groups,
Right.
for the historically marginalized groups. And I think that in many cases, I think blacks are getting the short end of the stick, because there are other groups, that are ahead of them in this, because marginalized groups, I mean, there's almost like an endless supply of these groups. And I think that we need to go back to principles of non-discrimination. If we go back to principles, if we go back to our Constitution and our civil rights laws, then I don't think we have a problem.
That's right. I agree. We're going to have some questions from our committee here. Representative Lynn, you're first.
Dr. Swain, thank you so much for being with us today. I consider it a great privilege to speak with you one-on-one like this, and I feel like I'm watching my TV, but I get to talk back and you can actually hear me, so I see you a lot. But thank you for being with us here today. And I completely agree with the intent of this bill. I mean, about 4 or 5 years ago, I found a book on critical theory, not critical race theory, but
Right.
critical theory. And because I was trying to figure out what are they doing and how are they doing it. And I found this book on critical theory, and it really explained exactly how they're twisting people's minds. And, really what we need to be teaching is how to be a critical thinker, not a critical theory or critical race theory or anything like that. And I truly see that right now we are at a time where there's oligarchs, and they're really teaching anti-American and communist theories. And it is absolutely disgusting. And what's more disgusting is that when people don't recognize it, that is really, really harmful when people don't recognize it. And, you'll have conversations with people in the community, and they have been taught these things, and they don't recognize it for what it is. And it's very disappointing. This bill has to do with business, and, it would be wonderful if we could just do this, but can you explain to me, if we pass this bill, how would a court not say that we are limiting free speech, because free speech is even speech we don't like. It's speech we don't like. And none of us like when we hear people talking communism, and it's really they're teaching some very anti-American things. But how would we defend this bill in court that we're not limiting free speech?
I think that you're actually protecting free speech and the First Amendment rights of employees not to be compelled and forced to engage in activities that offend their conscience. And with private employers, they have their own First Amendment rights. And so, universities mandate their employees to participate in it, and people can lose their jobs if they don't. And so I think that if it is confined to government employees and employers and contractors, that you own the safest constitutional grounds, because the problem with the mandatory training is that it forces people, and there are all sorts of ways, to force people to do things, and even being silent, like when they're having, sometimes gay pride activities, and they tell everyone, to wear a particular color. If you decide you don't want to wear that color, you've outed yourself, but maybe you don't do that kind of thing. Some people just don't go along with certain things. They have their own routines, but you can get yourself into a lot of trouble. And so the problem is that they are, I believe, violating some people's First Amendment rights because they are compelling them at times. They have been situations where white people were compelled to all confess their racism, because with critical race theory, it's assumed that all white people are racist, all white people are privileged, all minority people are victims, and if you try to protest, there can be consequences. And so I think that people have First Amendment rights, and they also have rights against racial discrimination. When we passed the 1964 Civil Rights Act, it prohibited discrimination on the basis of race, color, national origin, sex, and something else. I'm skipping my mind right now. But what'd you say? Yeah. But it prohibited discrimination, and it protected white people too. And for the longest time, a lot of white people have not known that they have civil rights too. They do have civil rights too. And back in the 70s and 80s, and I guess even in the 90s, when white people talked about reverse discrimination, everyone laughed. Now I think that they can make a case that's easily documented. And so I believe that certainly if you pass this legislation, and you can find it mostly to state government employees, that you own safe ground, and then with the private employers, they may continue to discriminate, but in some cases, people have documented them engaging in racial harassment, and they have been able to settle cases. And so I think individual employees that feel like they're victimized, they're going to have to collect their data about the discrimination that's taking place in their on their jobs, and file EEOC complaints or file other discrimination complaints against their employers. But I think that this legislation is the right thing, because it's compelling people to do something that may violate their conscience because of the color of their skin, or because of their sex, or because of, in some cases, it's heterosexual versus homosexual, with the perception that all heterosexuals are guilty of oppression. And you mentioned critical theory. We're focused on critical race theory, but critical queer theory, critical feminist theory, critical class theory. There are a lot of critical theories. They're all based in Marxism. They all divide people, and they're all rooted in conflict theory.
Okay, thank you. And Representative Lynn, and got to
Just-
just kind of stay on our bill a little bit to make sure we're directed toward
Right.
what the bill is actually trying to do.
I'm
Okay,
gonna
thank
But I'm not
Bring it back.
speaking here as a constitutional lawyer. But
Representative
I'm speaking
Lynn.
based on my knowledge of civil rights laws.
I will ask the sponsor when he comes up, but I think this bill only would, especially since the fact that it's in this committee, would only apply to businesses, but I will clarify that with the sponsor, because it would have to go to another committee if it did not only apply to businesses. And I'll tell you, my husband and I exercise our economic power constantly by not shopping at businesses that are doing these things. We absolutely will not give our money to those businesses, and as a result, we've been shopping locally much more at our community businesses where we know the people who have good values, and they're not trying to indoctrinate or brainwash their employees. And listen, I think it's a terrible thing. I absolutely think it's a terrible thing, and I hope that everybody will utilize their economic power and teach these businesses, we're not going to put up with this anti-American rhetoric. This has to stop. It is clearly communist and anti-American.
One thing I do know is that non-discrimination is the law, and that covers private as well as, government employees. And so if companies are discriminating against people because of their race and forcing them to do things, I think it does violate the 1964 Civil Rights Act and the Constitution's Equal Protection Clause and some parts of the First Amendment, depending on what they're doing. And I'm speaking as not as a constitutional expert on the bill. I'm sure you have plenty of people here that can do that, but based on my knowledge of the law and what I have seen taking place in workplaces.
With this General Assembly, we are rooting it out in government. We are, everywhere we can find it, we're trying to put a stop to it because everybody should be treated the same. And we've passed a number of pieces of legislation that apply to government and public schools to try to root this out. When it comes to private businesses, I don't know what
But
a
private
court would say.
businesses are not free to discriminate.
Yeah.
You
No,
have rights.
no, they're not free to discriminate, but we're talking about them having, having seminars and, our sponsor is an attorney, so we'll talk to him and we'll find out from
What
him.
takes place in those seminars, because in some of those seminars, people are required to say certain things. Yeah, and I mean, if you would actually look, which I have, at some of the things that have taken place during some of those DEI trainings, and there's no standard to be qualified to do a training. Almost anyone can hang up a shingle and go out and pass themselves off as a DEI trainer. So that is problematic.
Okay.
It needs to be policed better if that's going to be the norm.
Okay. Thank you. We have some other people want to talk to you too and have some questions. Chairman Bricken. You're passed. Okay. I'm sorry. Is that it? Do we have any more? Do you want back on the bill? Okay, yeah. Do you have any more? Okay. Anyone else? Well, thank you so much for being here today.
Thank you.
We really appreciate it, and honored to have you and to get to talk to you one-on-one, and we agree with so many things that you were talking about. But
Well, I
we
hope it was
really,
helpful.
yeah, thank you for being
Thank
here today. Appreciate it. And we're going to go back in session. And Representative Griffey, do we have any questions for him? Chairman Faison.
Thank you, Mr. Chair. Representative, glad to see you here. I'm a daddy to a biracial son, so I have definitely spent some time trying to get my mind around the whole notion of what critical race theory is, where it's being pushed, and I find myself agreeing that critical race theory is a dangerous thing. However, this bill has nothing to do with critical race theory. From my understanding, and I'll ask you that question in a minute, but I'm a business owner. I have pest control, several employees. And my short 12 years up here, I often thought, what is the ripple effect of the policies that we're making? What's going to happen tomorrow because of what we've done today? We are setting up a foundation of what somebody else can build on. I've been told that the party in power always likes big government. This bill feels that way to me. And here's what makes me nervous. At my pest control business, there have been times that I've provided lunch for everybody. We'll pray. There's been times that we've had a Bible study at my pest control business before business starts. Your testifier brought up that if this violates my conscience, I ought not be forced to do it. My thought to that, if it violates your conscience, you don't have to work at my pest control business. And I want to know from you, if we set this foundation up to decide what curriculum a private business can teach their employers. What stops us in the future from telling the private business, you can't teach the Word of God? You can't teach this. We are creating, and from my understanding of this bill, we're creating a foundation to tell businesses what they can and can't teach in their private business that they own. I pay for the lights. I pay for the chemical. I pay for my employees. I built this business. And now I feel like government, if we passed a piece of legislation like this, is coming and tell me, this might be yours. You're paying taxes. You're doing everything right, but we don't like what you're teaching. And so we're going to set up a cause of action for your employee to sue you for violating their conscience. How am I misunderstanding this bill?
Representative Griffey.
Thank you. Well, this would be my response. This bill that promote these, I believe there's nine principles that I think are discriminatory practices in sit there and listen to Bible verses. That's going to offend a Muslim person. He may not want to have to sit there or risk losing his job with that. And I would suggest potentially you could face a lawsuit over that.
I'm sorry, can you turn your microphone on? I think it might
I'm sorry,
might have got off. That's okay.
I'm sorry, I'll get closer.
Okay.
So I think you could possibly face a discrimination case in that instance. And so that would be sort of the same thing with this bill. And I think what we're trying to do is protect against discriminatory practices by an employer, because these principles, these 9 principles that are laid out, that one race or sex is inherently superior to another race or sex, an individual by virtue of an individual's race or sex is inherently privileged, racist, sexist, or oppressive, whether consciously or subconsciously. An individual should be discriminated against or receive adverse treatment because of the individual's race or sex. An individual's moral character is determined by an individual's race or sex. An individual, by virtue of the individual's race or sex, bears responsibility for actions committed in the past by other members of the same race or sex. An individual should feel discomfort, guilt, anguish, or other forms of psychological distress solely because of the individual's race or sex. A meritocracy is inherently racist or sexist and designed by a particular race or sex to oppress members of another race or sex. Promoting division between, resentment of a race, sex, religion, creed, nonviolent political affiliation, social class, or class of people, or ascribing a character trait, values, moral, ethics code, privileges, or beliefs to a race or sex, or to an individual because of the individual's race or sex. So what this bill will actually do is prevent employers from engaging in discriminatory practices. Again, I don't think we have any constitutional problems with this because it's voluntary. If an employer wants to put on these principles that outline these things, an employee can certainly sit there and listen to it if they want to. But I don't think we should allow an employer to take adverse employment action against someone if they choose not to sit through these inherently un-American, prejudicial, discriminatory practices, indoctrination, and training. And in fact, we already do that in our Civil Rights Law of 1964. We don't allow people to take action against other people based upon their race, sexual preference, creed, belief system, religion. So I think this is an addition to and not a additional burden or hurdle for an employer. And Mr. Chairman, could I please get a roll call on this bill, please?
I'm sorry, we have a policy, and you have to do it right when you first come up. You have to inquire about a roll call. We could have done that at the beginning, but
well, I've never seen that. I've never seen that in the rule before. I've heard that, but I've never seen that written in the rule.
It's in ours, yeah.
It never says you have to do it before. It says before the vote is what my understanding actually says.
Take a brief. Yeah, okay. We got a clarification, but it has to be done before any vote is taken on the bill. You're right. we've already voted on the amendment, so we've already had a vote on the bill. Sorry. Okay, Chairman Faison.
Thank you, Mr. Chair and committee. Just hearing what he would say, I want to tell you briefly about my pest control business. It always comes back, since I own a business and this law would affect my business. Well before masks became political in my pest control business, when you get hired, you are told that you will wear PPE, proper protective equipment. I make them. If you're going to work with me, you're going to put on gloves, you're going to wear a mask every time you're spraying at somebody's house. Now, as we got into the pandemic, it started to bother people. There was some people like, why are y'all wearing a mask? Well, we always, our boss makes us wear a mask. A couple of my guys like, Jeremy, this is so crazy that and it doesn't matter how crazy that some of our customers don't like it or this or that, or it's political now. When you came here, you understood what I was going to do as the business owner. Committee, we are getting into a place now that we're telling a business owner how you feel can't be shared with your employers. But guys, this is my business. I agree that critical race theory is not right. However, I don't agree with telling me what I can and can't teach. And I'll leave the committee with this. What we do today has a huge ripple effect tomorrow. There will be somebody else there years from now standing in that well who doesn't like what's being taught, what's in vogue then. Guys, this is incredibly dangerous. And remember, if we're not careful, whatever power, whatever party is in control is the party of big government. I don't ever want to be known as that.
Representative Griffey.
Thank you, Mr. Chairman, and thank you, Chairman, for those comments. This is my response. There's a difference in whether you require your employees to do or not do some kind of action based upon some non-discriminatory, non-belief system. But when you start requiring your employees to adhere to a religion, political philosophy, whatever, that's where we get dangerous. And that's what the Civil Rights Law is already designed to protect. And again, I submit this is an enhancement to it to prevent a distortion and an anti-American indoctrination program from filtering into our state of Tennessee. And I would ask you to pass this bill on that basis. Thank you.
Okay, and we've got a couple other questions too. I have one real quick. Don't they, based on what you already said and what Dr. Swain did about the Civil Rights Act, don't they already have a personal right to action if they're in disagreement with that? Isn't that already part of the law? I know you're a lawyer, and so you know that. So I can't. It looks like it's already in the law that they have to add.
There is a cause of action for any discriminatory practice, and arguably, some of these principles, there may be some question. I think if the state of Tennessee passes this bill, this, I think, lays out clearly that, and we've done that for our school system and what we teach our children. So if it's good enough for them, why would it not be good enough to protect every Tennessean simply want to go to work and do a job, whether it's pest control business, work in a factory, be whatever. They don't want to have to engage in discriminatory belief system against somebody else based upon the color of their skin.
Thank you. Representative Lynn.
I completely agree with everything that you're saying. The list of things that you have in your bill, nobody should be teaching that to their employees. It's ridiculous. It's absolutely, nobody should be teaching that. But you did say something about the bill, and that's not what your bill does. This says, a person shall not require an individual employer applicant for employment to complete or participate in training, orientation, or any other instructional informational program that promotes any of the following concepts. I think the following concepts are absolutely egregious. And as you know, we are rooting them out in state government and education. We are rooting these things out because as the General Assembly and the legislature, we have a right to root that out of government. How does this, I can see if the employer made the employee say, I am bad because I'm white. They violated their constitutional rights, absolutely, their civil rights, absolutely, they have violated that. But how, if we pass this, does an employer not bring us to court and say, I'm simply having them participate in training or orientation? They're not necessarily require them to repeat something or believe something or change their creed. Of course, we know this brainwashing will have an effect on people, unfortunately. But how do we not, how does the state not end up in court for these things? Because what your bill isn't saying that they can't make an employee sit there and say, I'm bad because I'm white. They can't do that. But your bill's not saying that. That's not what your bill is saying. Your bill is really, unfortunately, on free speech we don't like, absolutely, we don't like, but it's a free speech type of bill. And how do we not end up in court with a court saying, yeah, there's some speech we don't like, but even that's still free speech? I don't know.
Representative Griffey.
Thank you. It's very likely if an employer does get sued over one of these principles, an employee says they violated it, well, what will probably happen is if an employee brings an action, says that they were forced to sit through one of these things, and they file discriminatory action against the employer is going to file a defense and saying that statute is unconstitutional and violates my rights of free speech. Because it's a challenge to the Constitution of a state statute, the Attorney General is going to have to defend that, look at the case, and make a decision whether to file an appearance or defend it. I think when we passed this for K through 12 education, I think we had some concerns about that, and I felt like everyone in the General Assembly was pretty safe that it was not unconstitutional for us to limit this anti-American Marxist discriminatory practices from being put in place and taught to our children. And based on what Dr. Swain is indicating, employers are doing this. They are forcing certain employees based upon the color of their skin to admit certain things, being shamed or felt bad regarding nothing else and based upon the color of their skin. And that's what we need to get past in America. The color of your skin has nothing to do with the content of your character. And this bill is designed to protect that, enforce that, enhance that, promote that, American principles. We got to all come together as Americans. And this is nothing more than divisive, derisive, brainwashing that I think the state of Tennessee has legitimate, compelling interest in protecting all Tennesseans from being subjected to discriminatory practices.
Mr. Chair, I think what you just described about the employee has a cause of action there. They absolutely have a cause of action there. They do. I just don't know that, that we would win based on what your bill says. Your bill's not actually saying what you're saying. And that employee, if they're forced to say something, repeat something, whatever, they have a cause of action. They absolutely, right now have a cause of action. I don't know. I'm not a constitutional law scholar, but I've sat through enough committee meetings to realize when we might be treading in a free speech area, even though it's speech we despise, we hate it. It has to do with not government, it's private, and we have the right to say, government, you can't do this. Schools, public schools, you can't do this. Absolutely, we have that right as the legislature. I think what has been shown many times is that, unfortunately, even speech we don't like, we don't always have that power. But people do have the power to sue their employer if their employer is violating their civil rights or their constitutional rights.
Representative Griffey.
The employer still retains absolute freedom to promote these principles, do whatever they want to, speech about them, whatever. What this bill is saying is you don't have a right as an employer to force an employee to sit through this derisive, I think unconstitutional, discriminatory practices, because what it does is it targets people based upon the color of their skin, their religious belief, their sex, and so forth. It's the flip side. It's the inverse discrimination. And this bill is designed to prevent that.
Are you done? Chairman Vaughn.
Thank you, Mr. Chairman, and Bill Sponsor, thank you for bringing Dr. Swain. I appreciate your words today, and we've spent a great deal of time today talking about things that are on a lot of people's minds, and have a lot of people share concerns with regards to what you're talking about. But you know, unfortunately, we're not here to espouse our belief system with regards to various matters that are here. Even if I may be in violent agreement with your presenter and her thoughts on it, we're here today to vote on a particular piece of legislation and how this piece of legislation deals with and treats businesses in the state of Tennessee. The one thing that I would note, two things I'd note about the testimony that we've heard today is that we've already heard that individuals have protection under the Constitution and under the existing civil rights laws to bring cases for discrimination. We've heard that in testimony from both the sponsor and our the expert that he brought. So people have remedies if they find themselves in this position. And with regards to, I think it's something that the doctor discussed, and I picked up on a word that was very, it kind of rang true to me. And the reason that this legislature has been concerned about these issues in our educational system is because in that setting and in that environment, she used the word compelled. Children are compelled to be there to listen to it. No one compels you to stay at a job. There are lots of things that go on in jobs every day that people take offense to, whether it's not getting the right hours that they want, whether it's they have a coworker that is rude and mean to them, they have a boss that's not understanding. And so people have the ability to be mobile and to get out of the environment, whatever environment their employer chooses to put them in. Whereas in cases, school children do not. And that's one of my concerns here. The other issue is getting back to the bill itself. Let's take this out of the sphere of theoretical and get to the bill. This is a trial lawyer's dream. I mean, if you think about it, I'm not an attorney, so I'm not trying to, I don't like conflict in courtrooms. I don't think that it's a good thing to promote business. And whenever this sets up a cause of action to pursue up to $750,000 for non-economic damages, that to me is one of the most anti-business pieces of legislation that we've seen in a while. It's a trial lawyer's dream. It says people can come along and say, well, that's what I was made to do. That's what I was told to do. So therefore, Mr. Business Owner, you're going to have, as opposed to me leaving your employee, I'm going to file suit for you. The next thing we can do is, I imagine you know how we see the asbestos lawsuits and the hernia screens and all that stuff. That's the type of, whenever employees become offended by what their employer is doing in the workplace and give them a private cause of action, I think this would be a tremendous detriment to our business community. And that's why, Mr. Chairman, I think I'd really like to vote on this, but instead I'm going to move that we send this to summer study. Yeah, I can't call the question.
Going to go to summer study then. Sorry. Thank you, Mr. Sponsor. Item 5, I've lost my place. Okay, yes, here we go. I'm sorry, Chairman Faison.
Thank you, Mr. Chair. Just could I take a second from
Sure.
personal privilege? Y'all see this cute little cotton top lady right here? That's my mom. She's the whole reason I'm here, and that's my two youngest boys, Tucker and Asher. Y'all make them feel welcome.
Thank you all for being here, and thank you for making him my office mate when we first got here. I learned a lot from him. Not really, I'm kidding. Okay, item number 5. Chairman Holsey, are you still here? Hey, all right, great. House Bill 2068 by Chairman Holsey. Chairman, you are recognized.
Thank you, Mr. Chairman, and if you'll indulge me just a minute, I'm probably going to take this bill off notice, but I wanted to explain it because there's a lot of confusion about it, and I have no luck when it comes to bills in front of this committee, so.
Chairman Holsey, do you want to put the amendment on before you talk about it, or
If
you just want to talk
if you
about
like,
it? Okay.
I have Amendment 013917.
Oh, yeah, we need a motion on the bill, first of all, for him to talk. And a second? Okay, you got that? Now we're going to have an amendment. Okay, I got a motion and a second, 013917. Is that what you have?
That's what I have.
Okay, motion and second. All in favor say aye. Aye. All opposed? Okay, the amendment's on the bill. Now let's talk about the amendment, if you don't care.
Okay, the amendment exempts out everybody under Title 68 and 33 from this bill, which is your medical people.
Okay. And I'm sorry, we've already voted on the amendment, so if you want to go ahead and describe the bill as amended.
Okay, the reason that I brought this is because when OSHA mandate was still in effect and we were under the charge of Emperor Fauci and all his minions, it seemed at that time that businesses were taking unvaccinated people and discriminated against them and forced them to test, and in some cases up in my area, were forcing them to test every week and making them pay for it. And my whole gist of the bill was that it's unjust because unvaccinated people are not who's spreading this the most now. It's vaccinated people. Nobody likes to hear that, but it's the truth. Up where I live, there's a big hospital system that 2 weeks ago had 800 people out sick with this virus. 79% of them were fully vaccinated. The last numbers coming out of the European Union 2 weeks ago took the country of Ireland that has one of the highest vaccination rates in the world, 92%. And yet their infection rates are soaring. And of all the people who died in Ireland from this virus between April and October were fully vaccinated. 44% were fully vaccinated. So I was just trying to level the playing field and take the discrimination off of unvaccinated people. And the bill said, the gist of it was, if you're going to test unvaccinated people, you got to test vaccinated people because both of them are spreading it. So, but because OSHA died down and a lot of companies have changed their policies in this regard, I don't think I need the bill anymore. So I'm asking to take it off notice.
Okay, do you still want to? We have a question before you take it off notice. If you would like to talk about it a little bit, Representative Powell.
More just a comment, Chairman. I just want to let you know I've been carrying cash ever since your last bill that you presented. So thank you for that.
I do appreciate that. And in the defense of Democrats and Democrat thinking, I want you to know that the most liberal city in the United States, which is San Francisco, controlled by Democrats, actually passed an ordinance say that you cannot refuse cash. So there you go.
Without objection, we're taking it off notice. Okay, thank you, Chairman Halsey. We'll pay you in cash. Okay, the next one is item number 7, House Bill 2733 by Chairman Wendell. Chairman, when you get to the podium, you're recognized. We got a motion and a second.
Mr. Chairman and members, the governor's office has drafted an amendment which is amenable to both myself and the governor's office, and I'd like to ask for 1 week for them to have the amendment drafted, and we'll file it before the deadline.
Okay. All right. Thank you.
Thank you very much. My new neighbor.
Appreciate that, neighbor. 1 week. Okay. So that completes the regular calendar. We do have an addendum calendar. Yes. We do have an addendum calendar, and that's House Bill 2304 by Chairman Boyd. We got a motion and a second. Chairman Boyd, you are recognized.
Thank you, Mr. Chairman, and Chairman, I appreciate you allowing me to get this on the calendar today while the mortgage loan originators are here visiting today. And so this bill simply clears up some ambiguity in statute with regard to mortgage loan originators when they need to work outside of their offices. So this defines a remote location as other than the licensed facility. It makes sure each company has security policies and procedures in place that protect consumer data and records. It ensures companies, the remote employees, or the mortgage loan originators comply with the procedures of all federal and state security laws, and it makes clear no customer interaction can take place at a residence unless it's a licensed facility. Mr. Chairman, I'll take any questions.
Okay, is there any discussion on the bill today? None out? Move it out. Got the question on the bill. All in favor say aye. Aye. All opposed? The ayes have it. Your bill moves on to full commerce. And so, are there any other announcements or anything by the committee at all? Okay, well, thank you all for being here. I want to thank the Mortgage Lenders Association for being here, and appreciate you all coming out. And with that, we'll be adjourned.